Welcome to our latest webinar in a series here at GW Law School's Government Procurement Law program. The webinar today is about reshaping federal procurement. It's about a proposed rule that will have a number of very important impacts on the way that debarments are carried out in the federal government, and then likely collaterally, potentially across the country, potentially across the world, because a lot of the procedural remedies that are being put in place, a lot of the reforms are being put in place by the proposed rule could be useful lessons for around the world. This webinar is the latest in a series of webinars that we've done. The recording and materials from this webinar will be available on the GW Law Government Procurement Law YouTube page, and also be available on the program page, where we've gathered materials for this program at publicprocurementinternational.com. The video should be available in the next few days. Please feel free to check back. Today we have while the chat is enabled, it's better to use the Q&A, because if you use the Q&A function, which you see there on the top of the screen, if you use the Q&A function, which is on your screen, then you'll be able to get responses from all the panelists. So I encourage you to use the Q&A function as opposed to the chat function, if you at all can. I do want to emphasize that the statements of the speakers today are in their personal capacities. The speaker statements are in their personal capacities. We're very happy to announce that we've had nearly 250 registrants from 23 countries from around the world. You can see from this map here, we're really delighted to be able to share lessons regarding debarment with our colleagues from around the world. As we'll be discussing today, we're focused today is on the U.S. system, but really debarment systems are taking off around the world. They are becoming very important, and they're under consideration in many countries. So, for example, the United Kingdom, which just last year put in a new place, and they're implementing a new procurement law. The United Kingdom has a very aggressive debarment provision in it, in that new law, and it'll be, I think, an exemplar for other countries, because the United Kingdom has really turned a corner in its new procurement law, and it's focusing on issues of risk and how to mitigate risk through debarment, an important theme that we'll be returning to again and again today. Our panelists today include Sarah Drapkin. She serves as a suspension, debarment, and whistleblower manager in the Office of the Procurement Executive at the U.S. Department of State. Duke Wynn, who's a former debarring official at the EPA and is now a managing director with Affiliated Monitors. He lectures with us in our debarment course, and the students from our debarment course are with us here this morning. He lectures with us in our debarment course together with Maria Swaby and, of course, John Pachter, who's a co-professor as well in the debarment course at GW. John is now senior counsel of the international law firm of Haynes Boone, and he co-teaches, as I noted, in our seminar on debarment and procurement, debarment. John really brings a wealth of experience, both as a lawyer and representing contractors in debarments, as a monitor, and also importantly, he was involved in the very early stages during the Vietnam War. He was a young officer handling debarment-related issues. So he has a very strong historical view of how the debarment system has evolved over time. Last but not least, we have Associate Dean Jessica Tolman. She writes and speaks regularly on debarment issues and anti-corruption issues at GW Law School. She's the head of our program. She also, and this is important, she co-launched the debarment course that we have, the special debarment course that we're just wrapping up at GW Law School. The materials that we're referring to today are at the program page of Public Procurement International. We've gathered together really a very diverse set of materials, including a number of articles that were written by practitioners, including historical articles. There's an important one that was done by Bob Meunier and Trevor Nelson. We'll be referring to that during the course of the session today, which talks about the history of the debarment rules. So I encourage you to go to the program page and get resources that you need from there. Again, the video from today will be posted on the program page, and importantly, it will be posted on the GW Law Government Procurement Law program page. The program page has a link, among other things, has a link to the proposed rule, and the proposed rule is the comments in that are due on March 11th. We're coming up to the deadline. There are proposed rules that are being drafted by the ABA Public Contract Law section, and there are comments that are being published, that are being prepared by the ABA's Public Contract Law section. Those comments are not finalized yet, but we'll be referring to them topically to talk about some of the issues that might be addressed in those comments. There are only 2 comments posted so far at regulation.gov, but we expect in the next few days to see many more comments pouring in on the proposed rule. So the goal of the proposed rule is to harmonize the federal acquisition regulation contracts-based discretionary debarment rules with the discretionary debarment rules for the grants regime. And Duke has a very unique perspective on this because as a debarring official at the EPA, he regularly worked in both regimes, both in contracts and in grants. The proposed rule is a proposed change to the FAR. So it's really to bring the FAR into conformity with the grants rule, the non-procurement common rule. And we'll be talking about how successful this effort is to bring the two sets of rules into alignment with each other. Importantly, though, the executive order from 1989, the executive order launching all this, made the two systems reciprocally. There is cross debarment between the two systems. So if a vendor is debarred in the federal acquisition system, the contract system, the vendor will also be debarred in the grant. So because the two systems have reciprocal debarment or cross debarment, it makes sense that the rules would be aligned with each other. I just want to click through some of the elements of the proposed rule, which we'll be dealing with in more detail. We talked a little bit about the background. I do want to emphasize that both the proposed rule and the most recent report by the Interagency Suspension and Debarment Committee, which is cross-linked on the program page, both make very strong references to issues of business risk. The issue I referred to before that is at the core of the new debarment provisions in the new UK procurement law. The idea that debarment is a means of accomplishing supply chain risk management. That's a very important insight. It's a very important principle informing this new rule and really the debarment regime as a whole. Importantly though, there's no change in the proposed rule to the FAR rule that says that upon notice of proposed debarment to a contractor, that contractor is immediately debarred. We'll be talking about that in just a minute in more detail. There is a conforming of the title of suspending and debarring official. We'll be focusing on that. Administrative agreements, convictions, pre-notice letters, and voluntary exclusions. We'll be talking about all these. There's some new aggravating factors that have been imported from the grants rule into the FAR rule. And importantly, the proposed rule would address how state and local proceedings should be handled. So with that, I want to turn it over to Sarah, who worked on the proposed rule. And Sarah, I wonder if you could give us a little bit of a history and the background to the proposed rule.
Yes, thank you, Chris. So just as a little bit of background, the ISDC has had a uniformed rule subcommittee for quite some time, over a decade now. There were always issues about, if we proposed a uniformed rule, where would it be housed, in what regulation, et cetera. In August of 2019, the committee decided to kind of go another route, which was we decided, hey, the NCR has a lot of updated language, specifically dealing with ways to provide notice that, currently the FAR requires a return request receipt via snail mail. So things like that would be really great in terms of updating the FAR. So we decided to kind of switch the route that we were taking in that committee. And we decided to use that time to go and update the FAR language using that NCR language, bringing over any of that updated language that we thought was applicable so that they were more in alignment rather than creating a unified rule. So we did that. And then we also decided, in order to be transparent, that we wanted to actually highlight some of the tools that SDOs have already been using, like pre-notice letters, to make sure that that was actually in the regulation so that everyone was aware and had that transparent background. So that's really just a brief overview of how the subcommittee, looked at what we were going to do in terms of bringing this new rule to light.
Thank you, Sarah. I want to turn to the next issue of who qualifies as a debarring official. Sarah, the proposed rule includes a definition of a suspending and debarring official as an agency head or as a designee of the agency head. And does this new regulatory provision that would define a suspending and debarring official, does it have any practical effect on debarment practice?
No, not really. There aren't any, separate suspension officials or separate debarment officials at any agency. This again was just making sure that the language actually matched what was happening in practice. So by saying it's a suspending and debarring official, it actually matches what we're doing within agencies. And so that's where we wanted to make sure that we have that consistency and transparency in the language.
Thanks a lot. So I want to turn to one of the thornier issues which is the question of whether or not a notice to a contractor that is being considered for proposed debarment, that notice under the current FAR rule and under the proposed FAR amendments, that notice is an instantaneous debarment in essence. It triggers a debarment process, even though it's just a notice. And that's been controversial, and it's very likely that the comments from the ABA public contract law section will address this because it has been such a controversial issue in the rule. So we've got the language here from the Federal Register publication, and the FAR drafters talked about some of the reasons for having this. Most importantly, that because there's a difference between grants and contracts, because those are contracts or actual business agreements where the government's trying to accomplish certain business goals, as opposed to grants where typically the government is subsidizing activity outside the government. The FAR drafters thought it would be better to keep the current rule where the notice would trigger in effect, an immediate debarment. The provenance of this rule is talked about when back to 1989 is talked about in the article that's linked on the program page by Bob Onier and Trevor Nelson. They talk about the fact that in 1989 there was a disagreement, a misunderstanding between GAO and the rules writers. The GAO thought that there should be immediate effect, and therefore the FAR rule was written to create immediate effect. But it's been a controversial point since then. The FAR drafters also cited another argument, which was that, at least with regards to criminal convictions, appropriations law often required that there be no new contracts entered into if a contractor has been criminally convicted in the previous 24 months. So another reason to create an instantaneous rule. But John, if I could just talk through this with you, what is your view as a member of the bar who's done a lot of work in this over the decades? Should the FAR rule align with the non-procurement common rule to state that a notice of debarment does not result in an immediate exclusion? You're on mute, John.
I think I may be more effective if I'm not muted. Yes, I think it's a missed opportunity here. The FAR Council chose not to align the FAR with the NCR on this point. And to me, this is the most important part of the NCR that calls for alignment with the FAR. You mentioned the comments of the ABA section of public contract law, and they're about to be released. I would refer the listeners to those comments when they're publicly available because they take a strong position on this. So here's the problem. In the NCR, a notice of debarment, as you said, does not result in immediate exclusion, but under the FAR, it does. So the FAR rule continues immediate exclusion under what the FAR refers to as notice of proposed debarment, but it's not a proposed debarment under the FAR. It is an imposed debarment. It happens immediately. And it brings to mind the Queen of Hearts in Alice in Wonderland, who said sentence first, verdict afterwards. So, and the council refers to the Appropriations Act, which is a kind of the historical basis for the FAR rule. But it says that debarment should be imposed where a contractor has a felony conviction within the preceding 24 months, unless the SDO, the suspension debarment official, has considered suspension or debarment and determined exclusion is not necessary. So this requires a determination, and it rules out peremptory exclusion, even under the Appropriations Act language. Now, if you look at the FAR 9.406-1A, the FAR itself rules out immediate exclusion. The three things that it states. First is the SDO must determine whether debarment is in the government's interest. Second, the mere finding of a cause for debarment does not require imposition of the sanction. And third, the SDO must consider the seriousness of the contractor's actions or omissions and any remedial measures or mitigating factors. So you put these FAR provisions together, and they compel the conclusion that a pre-notice letter should be the norm and immediate exclusion should be the exception. Now, it's commendable, I think, that the proposed rule, as Sarah said, recognizes the availability of pre-notice letters, and they're in common use among SDOs. And that's also commendable, but now we have recognition of them officially in the FAR, will. But the proposed rule really, I think, doesn't go far enough. Now, the council comments assert that the SDO needs two tools for immediate exclusion. One is suspension, and the other is the notice of proposed debarment. But as I say, and as the section of public contract law comments go into detail on, the SDO only needs one, and that is suspension. So if you just take the case of conviction, and I'll conclude with that. Take a conviction, should that be a cause for immediate debarment? The answer is no. The question now is, who is convicted? On what grounds? What steps did the company take in response? Is the person still employed? What remedial measures are now in place? The SDO cannot come to a conclusion on whether immediate debarment is necessary to protect the interest of the government without affording the contractor an opportunity to respond. What has prompted the regulations in the first place was a decision by the DC Circuit by then Circuit Judge Warren Berger in 1964. The case was Gonzalez versus Freeman, and it called for regulations with minimum due process requirements of notice of specific charges and an opportunity to be heard before the SDO imposes the sanction. So those, in summary, are my reasons for being concerned with the FAR Council not going far enough to align with the NCR.
No need to raise your hand, Jessica. I saw your
You could see see the facial expressions I was making, and not in response to John. John, I agree with your comments. This to me is the biggest missed opportunity that the FAR Council had, and I hope we'll still consider doing in this revision. It is not often that we see the FAR Council addressing debarment. It is a slow process. Understandably, people are working through a lot of different things, but this was a real opportunity for the FAR Council to make a meaningful change in an area that simply just does not make any logical sense. I appreciate that the FAR Council attempted to try to rationalize why these two provisions could not be harmonized, but it makes no sense. You know, logically, there should not be one standard for grants and one, or non-procurements, and one standard for contracts. Logically, a suspension debarment official retains the ability to send a notice of proposed debarment that does not have an exclusionary effect, while simultaneously issuing a suspension if they truly think that it needs to have that exclusionary effect. The reason, or one of the reasons we even have pre-exclusion notices, is because of the fact that a notice of proposed debarment or a suspension basically excludes the contractor. This almost eliminates the need. If you could just send a notice of proposed debarment that would provide that notice and not lead to an exclusion, we'd all be working from the kind of same page. But yes, I agree, it's nice that we have some acknowledgement about show cause letters, but I am not swayed or persuaded by the FAR Council's rationalization of this refusal to harmonize these provisions. We have a way to do exactly what it's trying to achieve. And I truly, truly hope that the FAR Council steps up in the final rule and actually harmonizes these provisions in a way that would be, to me and to many others, a far more logical outcome.
So just to follow up on that in terms of the theme of risk management, if debarment is a form of risk management, it's a way of managing performance risk and reputational risk, then to send a notice and make that an instantaneous exclusion seems an improvident way of dealing with risk management. If the goal is to make sure that you're managing risk in the supplier base, the best way is to use the pre-notice letters we're going to talk about in a minute, so that the debarring official gets a better sense of the risks, not only of keeping the supplier in the fold, but also pushing the supplier out of the fold. That's an emerging issue. That the SDO has to consider the competitive effects of pushing the supplier out of the fold as well.
Yeah, and I think what you put your finger on, Chris, is the beauty of the US system. And I don't hide the ball when I talk to audiences internationally. I think the US approach to debarment is a very reasonable way, and one that actually preserves and promotes competition, which is a goal of almost all procurement systems. So I agree with you. You're putting your finger on that issue, which is that it is a balancing act. And truly, if a contractor is not responsible enough to receive government business, then it should be excluded from the system. And we have those tools, and the harmonization would still provide for that option. But if not, you're creating a situation where you're simply eliminating a competitor in a situation where you're undermining competition. So I appreciate you raising that, because it really does highlight one of the strengths of the US system. Harmonizing these provisions would make it only that much stronger.
An ancillary question which David Robbins raised in an article in 2022. David Robbins wrote an article called "Is It Time for a Definition of Present Responsibility?" It was published in the Government Contractor. It was actually submitted as a part of an anonymous comment on regulation.gov, and I've linked it on the program page. And David argues that you can't have this gap in the regulations where you don't describe present responsibility. This discussion leads to how one would define present responsibility, looking to the business and reputational risks that the government faces. John, I want to go to an ancillary issue, which is the Federal Register says that if a contractor does not receive notice, it can make a case for non-receipt of notice, because FAR 9.406-4 allows a debarred person to seek reinstatement, requesting that the debarment period or extent of debarment be reduced. So this factual scenario is where the vendor has not received notice and is trying to then catch up with the agency, so to speak. Did you want to comment on this, John?
Yes, thank you, Chris. This is a welcome change. And as Sarah said, this deals with bringing us into the present from the past, and where the receipt was under somewhat antiquated circumstances compared to what we have available today. So what it says is that if a contractor does not receive notice of proposed debarment, it can ask the SDO to reduce the period or extent of debarment under FAR 9.406-4. I think it could be made clearer in the proposed change to contain an amendment to say to an exception to say to provide for demonstration of non-receipt of notice, where the contractor is able to demonstrate non-receipt. But this would require immediate reinstatement of the contractor, subject to receipt of notice and opportunity to be heard. The problem with 9.406-4 is it does contain a catch-all. It says other reasons that a debarring official deems appropriate, but we need the additional clarifying language, because in the past, when the SDO sent the notice to the last known address, for example, that was deemed sufficient, even if the contractor didn't receive the notice. But the problem the contractor had was it was deemed to receive notice and could not challenge the proposed ground of debarment, but was relegated to proof of newly discovered evidence, et cetera. So the change, I think, should be made clear and reinforced.
And Duke, Jessica noted that do you have a comment?
Yeah, thank you very much, Chris. Thanks, Jessica, for noticing. I didn't want to get away from the last issue with regards to immediate exclusion in the proposed debarment. I know that there are a lot of strong opinions expressed. Definitely a missed opportunity, but also you can disagree with the rationale, which I do. For example, they talk about how the appropriations prohibitions apply equally to grantees and recipients of federal contracts, but there's no argument there that they need to take away the immediate exclusion from the NCR. And so, why the discrepancy? But what I wanted to say, though, is that even if you disagree with the rationale, you can't argue with the fact that since at least 1972, the courts have endorsed a pre-hearing or pre-process exclusion. Now, as long as that exclusion period doesn't last over 30 days, you can see in Horn Brothers in the early 70s, the DC Circuit held that the government may temporarily suspend a contractor for a short period of time, not to exceed 30 days, prior to providing due process based on a finding of adequate evidence of or improper unlawful activities. Now, that is sufficient to establish a necessity for immediate action. That is what the courts and as well as federal agencies have relied on over the years to impose that immediate exclusion, whether it's at the suspension stage or at the proposed debarment stage under the FAR. And I don't know if it's it's a relatively thin read, especially if the exclusion period stretches on over 30 days, but there is a legal basis for that. Policy. As a matter of policy, it's perfectly understandable that the FAR community would not want to depart from that. And if anything, they would want the assistance, the non-procurement community to converge in their direction. So, I just wanted to provide some balance to the discussion here on that point. And to me, it's perfectly rational.
Thanks very much. We have gotten a question. There's going to be a question pending from one of the participants. For our participants, if you could pose your questions in the Q&A, we'd be very grateful. That way we can deal with them as a group. Okay, I want to talk about the definition of a conviction, and there's a new definition of a conviction in the proposed rule that would include a judgment or any other determination of guilt of a criminal offense by any court of competent jurisdiction or any other resolution that is the functional equivalent of a judgment establishing a criminal offense by a court of competent jurisdiction. And the FAR drafters said that the rationale for this revised definition of conviction is that fact-finding proceedings should not be necessary when there's a sufficient evidentiary basis that the contractor was responsible for the misconduct for purposes of a proposed debarment. So that really being able to rely on a criminal conviction or the functional equivalent of a criminal conviction. And this question of a functional equivalent is kind of interesting. So I wanted to pose a question for Jessica. What if a corporation, Jessica, is found liable for state civil damages under circumstances that in another jurisdiction could constitute criminally reckless behavior, where, for example, there's a collapse of a bridge? Is that a sufficient conviction? And relatedly, what about a foreign conviction? Would that be enough to warrant debarment? What are your views, Jessica?
Well, it's clear to me that the FAR Council is trying to address this in the broadest possible way in doing so. So it attempts to capture a broad range of scenarios that we previously did not, have captured necessarily. That said, my response to all of this is it's nice to know and have a definitive answer if you have a suspension and debarment official who always wants to be able to hang the debarment or rely on an actual conviction, quote unquote conviction as defined, however that definition is interpreted. They want to be able to point to that in making this for some sort of protective measure in the event that they get sued. But we all know that the beauty, again, of the U.S. suspension debarment system is that we don't need a conviction. Many countries around the world make debarment part of their criminal justice system, or they tie or require a conviction or some sort of judgment in order to proceed, because as we always talk about, and the way I frame it in my classes is your debarment system for protection or is it for punishment? And if your system relies on you demonstrating a conviction or some sort of judgment as ever it's defined within your system, then it's a form of punishment. You're not taking into account necessarily whether or not the company is still responsible enough to continue receiving contract dollars. You're only focused on what did they do and should we tack this on to what other penalties we're using. Chris, you often refer to this as reputational harm, that the governments tie these together because they're doing it more to protect themselves from the harm of continuing to do business with what's considered to be an unethical or non-responsible company. Here, we don't need this. So it's fine. We can have this if you have somebody who's extra cautious and wants to be able to rely on some broader definition to take an action. But the way that the FAR provides the way that the FAR addresses this is that and thank you, Duke's also providing some additional nuance into making these decisions. The way that the FAR, it gives broad discretion to suspension and debarment officials to protect the government from non-responsible companies. So you don't even need it. And you don't have to have something fit neatly into a broader definition in order to proceed. And so I think that's an admirable quality of the U.S. suspension and debarment system, in that it gives such broad discretion to take actions to protect the government and doesn't narrowly focus on an actual conviction, however it may be defined, which can often tie the hands of contracting officials or suspension and debarment officials in other systems around the world.
Yeah, just to put that, what you're saying in historical perspective, John discussed with our debarment class, when he was a young Army officer in the 1960s, convictions would come into the Pentagon from convictions from around the country would come in, and then debarments would go out. So it was a largely conviction-based system, and the system has evolved since then to be a much more sophisticated, much more nuanced system to address a much broader array of business risks. We want to talk a little bit about pre-notice letters, and the proposed rule put forward a new definition of pre-notice letters as written correspondence issued to a potential respondent in a suspension or debarment matter. The definition emphasizes, and the FAR drafters emphasize, that it's not mandatory, that it is an option. Interestingly, as far back as 2005, Joe Newratter, who was then the GSA suspension and debarment official, Joe Newratter put out a proposed rule that never went anywhere, but he would have put this into the GSA rules, the prospect of regularly using a pre-notice letter. And as a practical matter, they're regularly used now as a way for suspending and debarring officials to get a better sense of whether or not there are grounds for a suspension or debarment. And so the question that follows from that, from the pre-notice letter, is what goes with the pre-notice letter? How much of the administrative record is at that point shared with the prospective respondent? And importantly, the comments from the ABA Public Contract Law section will address this question: what administrative record should be provided with the pre-notice letter? And wonder, Duke, if you could address this now, what are some of the different approaches that are taken across the agencies in making the administrative record available to the respondent?
Thanks, Chris. I appreciate all the softball questions being lofted my way. But hey, first, I'm always a beat behind in trying to add to the conversation. If you can go back to the question about the definition of a conviction, I think that's pretty significant, because what that does is it opens up the universe of causes, conviction-based causes under the FAR, to be as broad as the universe under the non-procurement common rule. And why is that important? Well, it's because that takes into account other courts of competent jurisdiction. You have state and local judgments. You also have, and this was the case as well under the FAR, but you also have the ability to take action based on a non-prosecution agreement or a deferred prosecution agreement. Those are the equivalent of a conviction whenever there is an admission of liability. So what that does, in addition to all of those other fact-based causes, it allows the government to take an action under the conviction-based causes, which then prevents the ability, if it's the equivalent of a conviction, it prevents the ability for the respondent to request a fact-finding hearing if there are any genuine disputes of material facts. Not an insignificant advantage, I think, there for the government to avoid a delayed, the delay and the complexity of conducting a fact-finding hearing. But back to the question of the administrative record, this is a resounding yes, right? If the administrative record is not included with the notice, it should certainly be made available to the respondent. There should be specific instructions included in the notice to request a complete copy of the AR, the administrative record. And a party subject to a suspension or debarment must be given the opportunity to rebut evidence in the administrative record that provides the basis for the suspension or debarment action. These are the fundamental principles of administrative law and procedural due process. And those are adequate notice and a fair opportunity to contest or rebut the negative information. And no respondent would have a fair opportunity to contest or rebut if they don't have access to the information in the complete administrative record and the information therein.
Thank you, Duke. Jessica?
Yeah, I think, and thank you, Duke, for providing that clarification. I think that's really important, and particularly with respect to the impact of the definitional change with conviction. And I think that gets a lot to the nuance associated with it. One of the things I can, because I appreciate that I was critical of the failure to harmonize the notice of proposed debarment. But what I do appreciate about this proposed rule is that it's very clear that the FAR Council did take into considerations the kind of practical and more nuanced aspects of the day-to-day that an SDO encounters, or even somebody who's actually received one of these notices or is facing debarment proceedings. So it's very nuanced in it, and I think that it's incredibly helpful, especially with the administrative record, which shockingly there has been significant inconsistency among offices and agencies across the government when it comes to the administrative record. One would think that would have been a fairly straightforward approach, but alas, it was not. So the clarification, I think, on the day-to-day and the actual experience is very good. I do think, however, on some of what I consider kind of broader, holistic approaches to debarment, that's where I think we kind of lost some footing with this proposed rule, and that I'm hopeful will be readdressed in the final rule.
One of the points that we emphasize with our classes is that this issue of what's in the administrative record is going to be overtaken by open data. Both President Obama and President Trump signed laws on open data. The federal government is moving in that direction, but slowly. So eventually the administrative record will all be open and public anyway. So these issues of what's in the administrative record will go away. Maybe not in our lifetimes, but it will happen.
I was gonna say, whose lifetime is the United States?
Definitely not in mine. I've got my heart attack scheduled. So I want to talk about the factors for debarment. And what the FAR drafters have done is taken the NCR factors for debarment and added them over into the FAR rule. And they're referred to as aggravating factors. But in some ways, if you're an advocate for a contractor, they also can be used as mitigating factors, because you can say, hey, these don't really apply to my client. So they're here on the right-hand side. These are the additional factors that we added, whether or not the contractor has a pattern or prior history of wrongdoing, the frequency of the incident. So the contractor can say, hey, I don't have a prior history of wrongdoing, whether and to what extent the contractor planned, initiated, or carried out the wrongdoing, the kind of positions, whether or not it was senior people who were involved, whether or not the wrongdoing was pervasive, whether or not the contractor's principals tolerated the offense, whether the contractor has been excluded or disqualified by another agency for similar contact, whether or not the contractor has entered into an administrative agreement that covers similar contact, and whether or not there are other factors that are appropriate. So by taking these NCR aggravating factors, importing them into the FAR rule, there's harmonization then with the non-procurement common rule, with the grants and the contracts rule, but also a more in-depth analysis in the FAR process itself. As we referred to before, there's state or local input is now being recognized. Oh, I'm sorry. And I apologize. I skipped ahead too quickly. Did the panelists, did you have comments that you wanted to make on these new factors?
Yeah, I can say something about that. When and I've issued several dozens, if not hundreds, of debarment decisions, and FAR-based debarments are easier to draft. FAR decisions are much easier to draft because there are only 10 factors. I personally felt like it would be almost per se arbitrary and capricious to not address every single factor in the regulation. Even if they're not applicable, I would include them and then indicate that they're not applicable. Now you have as many factors under the FAR as you do under the NCR, which is good, but you can never have enough factors, right? There's always something that a creative respondent will point out that a debarring official missed. And so, having aggravating as well as mitigating factors, I think is important, because in practice, that's what debarring officials do anyway. The language in both regulations says that debarment generally does not exceed 3 years, but it can, as we've seen over the years, well exceed the 3-year standard benchmark for debarment, as well as come in under 3 years. And the only way you can do that is to consider both mitigating and aggravating factors. And I think what this does is it just kind of reflects reality in the business of doing these things and exercising discretion. And it certainly harmonizes the two rules in the sense that, it converges. It allows a FAR, an SDO taking a FAR-based action to conduct an analysis much, very similar to that, if not identical to what an SDO might do under an NCR action.
Again, just go ahead, Jessica.
The one thing I wanted to note about it is, and I agree with you, there's always going to be more, right? And also from a kind of list of things to consider, it's always important to remember these are kind of non-exhaustive in some sense, because of how broadly worded some of the factors are. But I do appreciate this really does reflect a maturity of the understanding and appreciation for evolving compliance programs and evolving nature of kind of settlements or decision-making when it comes to wrongdoing. It's very much some of this language, not all of it, but some of this language really does align with the language that you see in the DOJ's evaluation of corporate compliance programs. Also, it aligns with the language you see in the corporate enforcement policy, where you're looking at a lot of factors relating to kind of root cause analysis. You're looking to aggravating factors relating to the role of senior officials within the organization, kind of how did the company respond to these sorts of things. So there is almost harmonization of some of these same features. So we're seeing it in particularly because you see companies often dealing with debarment at the same time. It's also dealing with settlements with the Justice Department. So it's nice to have some sort of unity there. But the only thing I would mention though is that I think we see some more information related to kind of individuals in it, but we still don't have some of the things related to individuals facing debarment. And one of the complaints for a long time facing the system has been that it's harder for individuals to basically navigate the suspension debarment decision because a lot of the language is truly tailored towards the corporate or companies facing debarment. And I don't see more here that gives that guidance. That said, many SDOs say that they understand how to view these in context when dealing with individuals, and they don't need that language. But that puts a lot of reliance on an individual holding that suspension and debarment position. And we've seen time and time again that when you leave a system open, particularly that aspect of it, to individual personalities or individual capabilities, we can see things go sideways. So it would have been great to see elaborate more and help individuals in this instance, but I do think that this is progress.
Go ahead, John.
Yeah, real quick. I just want to point out, Jessica, the comments of the section of public contract law do deal with individuals. It's beyond the scope of the proposed rule changes, but it is important. Secondly, I think that an argument can be made that the aggravating factor issue is just simply the flip side of the affirmative obligation factor. So you could make that argument, but I do think that for the sake of harmonizing the rules, it's helpful to have a single set of factors that to be addressed in both the non-procurement and the procurement side. So I would go along with these changes.
It just, full disclosure, the reason I asked Duke about it originally was because Duke, as the SDO at the EPA, the Environmental Protection Agency, was dealing with both grants and contracts. And it's very heartening to hear him say that organically that these fit together very well. Okay, we have a couple questions that are pending. We'll get to those in a couple minutes. We have a hand raised. If you have a question, please feel free to put it into the Q&A. We'll be getting to those as soon as possible. So an important part of the changes, and Duke and Jessica referred to this already, is that with regards to the suspension actions, there's an explicit recognition that you can rely on state and local proceedings, that the SDO can rely on state and local proceedings, and that so that the FAR has been revised would be revised to revise the list of parties who can contribute advice on pending or contemplated legal proceedings to include state attorneys generals or state or local prosecutors' offices. The FAR, as the FAR writers pointed out, the FAR currently fails to take into account the suspensions can be based on state and local proceedings. The question I have for Sarah, because you're working with this stuff on a day-to-day basis, would this recognition of local or state proceedings, does this change practice for SDO's offices?
Again, actually, there's no practical change. It just recognizes what is already happening within SDO offices. We're already looking at state and local proceedings and using them in terms of suspension and debarment. It's just a matter, again, of recognizing that, putting it in the text so that it's clear and transparent for all those who are, getting a notice, that they're aware of what they need to know in terms of, what kind of action may come their way. And Chris, if I could just say one other thing, I understand the other panelists' frustration with the proposed rule not going farther. I would just say that in terms of what we were looking at and what we were really trying to do within the subcommittee is take the approach of doing what we could at the moment. Again, if you remember, we started this process back in August 2019. We really thought that it would be much quicker process and that it would start the ball rolling on, kind of updating and making changes to the suspension debarment world with kind of a first step, if you will, by making these harmonizations. Although I can understand the frustration, I think that really we wanted to just try and do this kind of what we thought might be a quick harmonization, which turned out not to be so quick, because we thought that would actually, again, provide the transparency and be a first step and maybe a process of bringing the suspension debarment standards up to date.
Yeah, go ahead.
Yeah, that's such an important point, and it's missed, I think, by a lot of commentators, how difficult and very winding road this has been. Recall that the Interagency Suspension or Debarment Committee stood up in 1986, was established precisely for this very reason, to affect reciprocity between the two rules and to ultimately harmonize and if possible, consolidate the two rules. And this was a significant first step. I mean, it's the first effort in a generation. I had to look up in Wikipedia, how long does a generation last? And it lasts about 20 to 30 years. Well, this is the effort in my generation. I wasn't there, at least in the procurement community in the 1990s, but this one is it. And there are significant remaining differences between the two rules, but we cannot understate the importance and the accomplishment, even if this rule comes to pass as drafted. It's a major movement. Now, with that said, there are still significant differences, and I can list them. I mean, differences in causes. For example, obstruction of justice is a enumerated cause under the NCR, not yet under the FAR. Knowingly doing business with an ineligible entity a a specific and identified cause that's not present in the FAR, different imputation standards, especially between organizations under the FAR and NCR. Administrative and agency level appeals are not authorized under the FAR. And so there are remaining opportunities to, to harmonize further these two rules. And certainly not least is the immediate exclusion or the immediate effect of a notice of proposed debarment. And so what all that goes to say is that, we plucked some low-hanging fruit here. Or the government did. And, and I think it's a great start, but it also opens the door to a continuing process of, of harmonization and convergence between the two rules.
Speaking of generations, Sarah, your father and I, David, we've been teaching the same procurement reform class on a rolling basis for the last 20 years. So the joke we use when a rule isn't quite complete, we say it doesn't go far enough. Poor Jessica.
Oh, I love a good play on words, so it's fine with me.
So I want to talk about administrative agreements because these are likely to be very controversial, and they are an object of discussion in the comments from the AB Public Contract Law section. I don't think I'm giving away too much to say that the bar is going to be focusing on this, because the proposed rule says that if there's an agreement between an agency suspending a debarring official and the contractor used to resolve a suspension or debarment proceeding, or a potential suspension or debarment proceeding, that agreement has to be posted on, and because the rule was drafted some time ago, there's a reference to FAPIS. It should probably be a reference to SAM.gov, because FAPIS has been pulled in to SAM.gov to Jessica's profound relief, because FAPIS was such a clunky platform. So Duke, if you could just comment on this, will the reference to administrative agreements and the posting on FAPIS and to the references to potential agreements regarding potential suspension debarment actions, does this sweep up a lot of agreements and force them into transparency?
Yeah, no, first of all, if you missed Jessica's expression, I mean, I think we need to eliminate all references to FAPIS, because it does stir up some very strong reactions and rightfully so negative images, especially among some of the panelists here. But yeah, let's leave FAPIS behind and move into the 21st century. The practical effect, it shouldn't, but I think it will. Since 2009. Section 872 of the 2009 NDAA, the National Defense Authorization Act, requires a posting on a database for integrity and performance, subsequently FAPIS, my last reference to that word, of all, quote, federal administrative agreements entered into by the respondent and the federal government to resolve suspension or debarment proceeding. That should have been clear, right? But it wasn't clear enough because a lot of agreements still did not go on that database. And so now, the FAR Council sought to clarify that not only those agreements that resolved or settled a suspension or debarment agreement should go on the database, but also an agreement that resolved a potential suspension or debarment proceeding should go on a database. And I think that should catch everything, but the temptation is there, I think, for a lot of agencies to resolve responsibility matters, but also not share them, with other agencies, other awarding officials, and with Congress, because those are the primary audience of this responsibility and qualification, I think, database.
Thanks very much. Jessica, did you want to comment?
Yeah, so thank you to Duke for mentioning it. I think of the words I used yesterday with regard to what I thought of FAPIS was dumpster fire. The worst website I think I've almost ever seen. So I've not used the SAM.gov component yet to make a judgment, but I'm sure forthcoming. So let me just say this about transparency and I think this is important. This is where I diverge. I get sometimes criticized where people think I'm a little too friendly to the bar, to industry, when it comes to debarment. I disagree with that characterization. Frankly, I think I'm pleading for a reasonable approach and one that balances competition with responsibility, which is still a necessity. But I truly think that a lot of systems could benefit from taking on the U.S. approach to this, to debarment. But when it comes to transparency, I think we really fail. The United States likes to pride itself on its ability to be fairly transparent in its procurement system. And indeed, it's more transparent than many procurement systems around the world. But when it comes to exclusion, we really do fail. And unfortunately, the link no longer works. I tried it yesterday, but we're working, and I'm working with the World Bank right now on the new survey. So we'll get this updated link. Guatemala, which truly is not a comparable procurement system to the United States in the sense of scope, size, and the way that we do business, publicizes, not only who has been excluded and information related to it, but it has the cause for it right there in a database that you can easily access publicly. And to me, even though I'm certain that its debarment system is probably not perfect, gives significantly more information to the public, civil society, the media, all the relevant stakeholders as to why a company has been excluded. And frankly, this, along with the administrative record, would be helpful information, not just for Congress, not just for, again, academics, but, frankly, one of the things that the government now expects contractors to do as part of its compliance programs is to vet its partners. And it is more difficult for companies to vet their partners if they don't have access to some of this information. So I appreciate that industry may not want its clients or may not want itself to be listed on a website, publicly accessible, have these agreements listed on a website that are publicly accessible, doesn't want the cause listed instead of the template boilerplate language that's currently used in SAM.gov. But from a transparency standpoint, one that I think every procurement system could benefit from, I would really love to see more available on SAM.gov for the public to look at when we're truly trying to understand the cause and some of the information related to why a company is being excluded or why a company is now under an administrative agreement.
So just to build on that, so what Jessica's referring to is a growing question across, not just in debarment. Debarment is really the tip of the iceberg across all qualification information, making all qualification information more publicly available. So for example, the Brits under their new procurement law are going to be placing contractor performance reports, what we would consider, what we lock up. They're going to make them public because that's part of a broad public risk assessment. So really a shift, and part of this may be animated by trade agreements, which say, no, you have to put the cause up. You have to, if you're going to debar somebody, you have to put the cause up. That could be part of very possibly part of a future trade agreement. The flip side of it, though, is in the comments from the bar are probably going to reflect this, the ABA Public Contract Law section comments. The complaint is that the concern is that if you put the administrative agreements up in public, and they sweep up all potential debarment action so that all agreements have to be published. The argument from the bar is that that's essentially punishing those contractors that have been proactive about bringing issues forward. That's the countervailing argument. Duke?
Yeah, so I mean, I absolutely agree with Jessica and Chris. The concerns about the openness and transparency, or maybe the lack thereof in our system. You don't have to look back very far, just back to when we had EPLS as opposed to SAM. There were 64 cause and treatment codes under the old system, and the current system only has 4. So we've actually gone backwards in terms of transparency. I won't mention other efforts, more recent efforts to firewall off information that was previously available to the public. But yeah, I absolutely agree. 2024, the prevalence of data and the need for data and all of this information, not just cause, but what we're talking about today, different authorities, different debarment regulations. You can't find on SAM who was debarred or who was excluded based on which regulation. And it's not like the agencies don't know this information is being tracked and collected. It's just not being shared with the public. And, I think the public could use and benefit, based on transparency and the need for openness and consistency and predictability in the system. I fully agree, and I'm consistent with the positions I took when I was in government, that we're doing the people's work. We should be more open and transparent about it.
Thanks very much, Duke. So we're
Yeah.
running short on time. I'm sorry.
Yeah.
Go ahead, Sarah. I'm so
I
sorry.
was just gonna say one really quick thing, which is that I don't think the word potential actually has that big of a practical effect in my estimation, only because the majority of cases I see that go towards an administrative agreement usually are the result of a voluntary disclosure or a pre-notice letter. So they really are based on a potential suspension and debarment action, and we haven't actually taken any exclusionary action yet. And that's what it resolves, that potential suspension and debarment action. So I think that in terms of my government hat, in my estimation, it just actually shows that that's the practical effect of looking at what might be a suspension and debarment action.
So we have two questions I'd like to get. I joked to the panel through a friend. Our time is kind of like soccer time. It's a little bit flexible. So the first question is from Craig Barrett, and you can see it there in the Q&A. Craig Barrett is a former student of ours, and he teaches with us in the program. He's a cherished part of the GW community. He says, in a former life, when I worked in the OGC office for a federal agency, the Office of General Government Counsel advised the suspending and debarring official, who was a non-lawyer, throughout the determination process upon receiving a referral from the Office of Inspector General, which initiated the process. Could you discuss the role of agency counsel and the OIG in this process from your experience? And is there an issue that this process may not be uniform across agencies? Does the panel have a view on that?
Yeah, I can speak to that a little bit. Hey, Craig. And by the way, Chris, usually when we go into extra time, it's because of penalties and injuries. So hopefully there are no low blows or slide tackles here. But, agencies are, as you know, Craig, are structured, suspension debarment programs are structured differently. And some agencies, the debarment program resides with the general counsel's office. Others, it may be in the grants or the procurement office, or there are some agencies that have freestanding suspension debarment programs. And so counsel play a different role in each agency based on the agency structure. Certainly, the uniform role that the general counsel's office or the solicitor's office play in different agencies, the one thing they all have in common is that if a matter were to be litigated, they will certainly have a role, because they will be coordinating with the Department of Justice to defend the case on behalf of the agency. And that is the norm, and that's why I think general counsel's office and solicitor's office need to play an active role, and not to provide oversight, because suspension, debarring officials need to have their independence and free from outside influence, but they need to have visibility over the actions that are being taken, as well as provide. There should be triggers in each agencies for conducting certain legal reviews, because there should be visibility by the general counsel when an action is being taken on behalf of the agency head. It can't happen in a vacuum. And so, yeah, there should be a lot of interplay and a lot of coordination between the general counsel's office, between counsel's office and the debarring official and his or her program.
Very good, thank you. So with the last question is from Alan Barak, and I'll read it, and then I have a first response, and I'd be glad to have any other responses. It has to do with an issue that Alan thought would come up more often in the development world. When a leading citizen gets convicted somewhere else, let's say in the developing world, doesn't that make it much easier for the debarring official to get him or her out of their procurement universe? So you experience this in Guam versus Northern Marianas politics. So the quick response is actually an interesting one. It's a database response, which I supervised a master's thesis by a student who was working in the money laundering apparatus, it's a uniform apparatus from country to country to country that Treasury officials have cooperated, the finance officials have cooperated around the world to create uniform money laundering monitoring systems. And in the Zambian system, it's a small enough system. So if you buy a car here, you're filling out a money laundering form that you spend over $10,000. So there's a huge amount of data because everybody who buys a car here is going through that system here. But in a smaller economy like Zambia, in a developing nation, they actually use the money laundering data to identify potentially corrupt officials. So the answer to the question is yes, this is going to come up more and more because the data is going to be available from this completely outside the procurement system database, the money laundering system. That's a very good example of information regarding politically exposed individuals that is going to be available to procurement officials in making debarring decisions. It's an indicator of where we'll be in 10, 20 years from now, where procuring officials, debarring officials are making either responsibility decisions or present responsibility decisions in the case of a debarment, using data from a much broader spectrum of potential information sources. Any other comments from the panel? Okay. Alrighty, I want to thank the guests. Thank you all our panelists for doing such a wonderful job. Thank all the participants for your excellent questions. As I said, the video will be available in the next couple of days on Public Procurement International, and it'll also be available, of course, on the GW Law Government Procurement Law YouTube page. And there's an archive there in the GW Law Procurement YouTube page, the Procurement Program YouTube page of many, many past webinars as well. Again, thanks very much to our panelists and have a great day. Bye-bye.